Hey everybody, this is Do-It-Yourself Kangaroo Courts number 13, Subrogation. Let's get going. Kangaroo Court, a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. When acting to enforce a statute and its subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administrating and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, as a bought and paid for clerk. It is the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for clerk. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as bought and paid for clerks for the involved agency. All oaths must be lawful, allowed by common law or some statute if they're administered by persons in a private capacity. Okay? And so this is taken from Tomlin's Law Dictionary, 1835, Volume 2. And what it's essentially saying, it's citing actually Book 3 and 4 of Coke's Institutes and the Laws of England. So this is as old as time itself. Government officials don't have to be operating in their official capacity. They operate in their private capacity all the time. And so the burden's on you to know whether they're operating in their official capacity or not. And so, because if they're administered, oaths are administered by persons in a private capacity or not duly authorized, they're void, and those administering them are guilty of contempt. All government employees, judges, police officers, etc., can be in their private capacity or their public capacity. An officer who acts in violation of the Constitution ceases to represent the government. If they do anything that's illegal or unconstitutional, they cease to represent the government and immediately move from their public capacity to their private capacity. They're bought and paid for clerks. A clerk masquerading as a judge is not competent to do anything judicial, like issue orders or warrants. A clerk masquerading as a judge is operating in his private capacity and has no immunity. Ministerial officers are incompetent to receive grants of judicial power from the legislature or acts in attempting to exercise such powers are necessarily nullities. Brutum fulmen. An empty noise, an empty threat, a judgment void upon its face, which is legal effect, no judgment of all, by which no rights are divested, and from which none can be obtained, and neither bars nor binds nor bars anyone. And so, watch my void judgment video, because that's what they make, is they make void judgments. I got a whole video on void judgments. Copies of these documents can be found in my private group at Yahoo called Administrating-Your-Public-Servants. For a complete set of YouTube videos with private information, shares a DVD with over 50 searchable law dictionaries and other books and forms, contact me privately at Engineer Win. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs. The Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for our particulars. If they spell your name in all block capital letters, then they're operating in their private capacity. If they're attacking you with a statute, then they're operating in their private capacity. Subrogation. That's what this video is about, is subrogation. This is taken from Black's Law Dictionary, 8th edition. Subrogation, the substitution of one party for another whose debt the party pays. Okay, so they know that the thing they're attacking is a cestui trust. They know that it's not you, and they're getting you to subrogate yourself or to be a surety for that fictitious entity. The substitute of one party for another whose debt the party pays, entitling the paying party to rights, remedies, or securities that would otherwise belong to the debtor. For example, a surety who has paid a debt is by subrogation entitled to any security for the debt held by the creditor and the benefit of any judgment the creditor has against the debtor, and may proceed against the debtor as the creditor would. The equitable remedy, that's definition of number 1. Definition number 2, the equitable remedy by which such a substitution takes place. And definition number 3, the principle under which an insurer has paid a loss under an insurance policy is entitled to all the rights and remedies belonging to the insured against a third party with respect to any loss covered by the policy. And insurance is a really good example of subrogation. What happens is when you buy an insurance policy, you get an accident, and even if the accident's not your fault and you have proof or whatever that the accident's the other guy's fault, the insurance company can completely ignore that and pay him off, and there's nothing you can do about it, okay? That's called subrogation. You gave up your rights when you bought that insurance policy. And then, well, you got to go do more than that. You got to basically call up the insurance company and file a claim, okay? When you do that, that's when the insurance company you subrogated your rights, okay? Now, in a court case, they know that you're subrogating the party, and so this is a strategy that people are doing or can do that is talked about. I'm going to have a soundtrack from a talk radio program that I'm going to have included in this video, and you'll be able to listen to it. And they talk about subrogation, okay? And because, again, it goes back to the first definition, the substitute of one party whose debt the party pays, entitling the party paying to rights, remedies, or securities that would otherwise belong to the debtor. And so, for example, a surety who has paid a debt by subrogation entitled to any security for the debt held by the creditor and the benefit of any judgment the creditor has against the debtor. And so, again, so you have rights if you're going to be the surety, and they know that's exactly what's going on. And when you bring this up, they are basically stealing that money, and when you bring it up, they'll make the thing go away. Okay, now watch. We'll get going here. There's more to cover. But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges, where they assume the rights, duties, and privileges of the artificial entity or association for which they are agents or officers, and they are bound by its obligations. And that's Braswell versus United States, quoting United States versus White. So, again, this is all about subrogation, okay? So they know that it's not you, okay? They are playing games so they can assault their Sestakay trust and get you to be the surety for it, okay? Did you give up your God-given rights for some satanic privileges? This is all coming from the UN, and this is all satanic, deceptive. Anyways, don't forget to subscribe to this YouTube channel. Don't forget to follow me on vid.me. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On vid.me, don't forget to upvote this video. On Steemit, don't forget to vote and make your comments. There's the front page of my channel. The subscribe button is normally red. It's clicked, and so that's why it's turned white. It says subscribed. It's checked. The bell is where you click, and it will show a little vibrating signal, which means you'll be notified about uploads. This is Steemit. The left arrow is where you do upvotes. The middle arrow is how many upvotes it got, and the right arrow is comments. And Steemits and upvotes and comments on Steemit are good. This is also Steemit, where you click on someone's profile on an article of some sort that you like or do. If you want to follow them, you click on it, and that's where you see the hand. There's my mouse, and the little window will come down, a little box, and you click follow or unfollow. So this is all about the Roman cult, and they're assaulting you with their Sestakay trust, and this is a remedy that you can have. Once you understand the law, you can make it so they don't want to talk to you, okay? Every taxpayer is a Sestakay trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction, okay? That's a summary from Inri Bolins in 1912 and a summary from the Congressional Record of June 13, 1967, 5 pages of the Congressional Record, I might add. is a citizen of the United States, is a civilly dead entity operating as co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive Cesticate Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And this is all coming from the Roman cult. This is all just business, okay? They have a bunch of pirates, a bunch of thieves that are out kidnapping and assaulting people to extort money, okay? This is nothing but a bunch of thieves. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's Roman cult, folks. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use and receiving the actual profits, while the season of the land remained in the nominal fiefs, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. Isn't that convenient, eh? The Roman cult gets to own and operate the courts, and so they get to determine what all this stuff means. And to be bound in conscience to account to as a cesticate use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And it was the foundation of modern. This is Tomlin's Law Dictionary, 1835 edition, under volume 2, under the definition of mort main. If it was the foundation of modern conveyancing in 1835, it definitely still is. Okay, this is all coming from the Roman cult. This is the DC Code, located at 31 Stat 1432. The legal estate to be the cesticate use. Okay. More DC Code, which was approved on March 3rd, 1901, at 31 Stat 1189, and at Section 2, where this is right up in the front. And be it further enacted that in interpretation and construction of said code, the following rules should be observed, namely the word person shall be held to apply to partnerships and corporations. And more DC Code, absence of 7 years, it gives them the presumption. They get to presume that you're one of their slaves, okay? At Section 252 at 31 Stat 1230, I'm not going to read it, but this is where they get the presumption that you're dead, which brings in the cesticate trust. And this is where it's codified. Did you give up your God-given rights for some satanic privileges? And this is Title 15, United States Code, Section 44, Definitions. Corporations shall be deemed to include any company, trust, so-called Massachusetts Trust or Association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest, and any company, and it has the same definition, except it doesn't have shares of capital or capital stock or certificates of interest. So that's definitely the cesticate trust. Announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 because it avoids the advertising only. But if you want to make it a donation, it can be a donation if you like my work. $1.99 is certainly a modest donation, but it's every little bit helps, and a lot of people chipping in a little can add up to a lot. The only power that the New World Order Satan have over us is through this fraud and deception, and my agenda is to expose it all for our benefits. I cannot fight all the battles. I need other people fighting the battles and being on point. I'm currently publishing one video a week. There's a link to the YouTube channel at the bottom because some people had trouble finding it. Some of the exclusive content is the Arlington Private Information Share, Land Deed Training, Estoppel Certificates Training, Foreclosure Estoppel Certificates Training, Corporate Denial Training, Toll Roads Notice and Demand Training, Invoice Training, Notice of Void Judgment Training, Revocation of Signature Training, Third-Party Witness Training, Federal Habeas Corpus Training, Revocation of Voter Registration Training, criminal complaint training. I'm going to put more criminal complaint training. I'm going to have some lawsuit training and other training. Everything that is needed to free yourself is available for free on my free YouTube channel, Sovereign Living. All forms, files, and other instructions are available for free on my 2 private groups at Yahoo Group and Google Groups. So this channel is for stuff that's above and beyond, okay, and you have to pay a fee to get it. With the training and stuff like that, you really don't need the training, and people can figure that stuff out without too much trouble. I do have free training on my free channel, but this one is there is extra training on this channel, and there's other videos that I'm going to have available on this channel. But YouTube is committing suicide. So YouTube has notified me that on the 1st of December, my feast-based subscription channel will be terminated because they don't want any competition for their YouTube Red or their YouTube TV. They have, in fact, someone actually sent me an email and said they had tried to subscribe to that channel and they couldn't. Okay, YouTube is blocking it. So if you want to subscribe to that channel, you can get the same videos by going to Sovereignty International on vid.me, and you can subscribe to that one. And there's a portion of the videos are fee-based subscription, and there's a couple different subscription levels, and so depending on what exactly you want. And so you can subscribe there and get access to it. Anyways, if they're assaulting you with the Uniform Commercial Code, they're operating in their private capacity. So what you do is you ask the judge, or is actually a court masquerading as a judge, will the plaintiff, which is the prosecution, certify that I have the right of subrogation? Okay, that kills them. Okay, that big time kills them. And we're going to have a soundtrack from a talk radio program that's going to be part of this video that you can listen to the discussion about subrogation. It kills them. My blog is SovereigntyInternational.wordpress.com. My website is SovereigntyInternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile, Sovereign Living and Sovereignty International, although the Sovereignty International one is going to be shut down here on the 1st of December. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group, called Sovereignty International, is being deleted. My Yahoo private group is called Administrating-Your-Public-Servants. My Google private group is called Administrating-Your-Public-Servants. Follow me on Twitter at EngineerWin. Follow me on vid.me at Sovereignty International. And follow me on Steven at Sovereignty International. Governments descend to the level of mere private corporation and take on the characteristics of a mere private citizen where private corporate commercial paper and securities is concerned. For purposes of suits, such corporations and individuals are regarded as entities entirely separate from government. That's the Clearfield Doctrine. There's two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And so this is Downs versus Bidwell and 1901. The point being is, which government are you under? Okay, one of them is constitutional and operates within the Constitution. The other one is unconstitutional. That's what they're saying there, is unconstitutional. These government bureaucrats have no duty to obey an unconstitutional law, and so they're engaged in treason, okay, and sedition. And don't get me going. And so, but which one are you under? Okay, obviously, if they're assaulting you, they seem to think that you're one of the slaves. Okay, the one maintained by Congress outside and independent of that instrument is a corporate, and it's for slaves. And this is in 1794, Chisholm versus Georgia, a case in 1794, U.S. Supreme Court again. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. A state is altogether exempt from jurisdiction of the courts of the United States or any other exterior authority, unless in special instances where general government has power derived from the Constitution itself. The question to be determined is whether this state, so respectable and whose claim soars so high, is amenable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others, more important still, and may perhaps be ultimately resolved into one no less radical than this: do the people of the United States form a nation? And this last sentence is the most important part of this whole thing. By that law, the several states and governments spread over our globe are considered as forming a society, not a nation. So what the Supreme Court is saying here is that there was no nations on the planet in 1794 except the United States of America. And do you think that's changed? Matter of fact, this two national governments, that's the one independent, that's the unconstitutional one, is the one that's the society, okay? You want to be part of that society? I don't. Anyways, so when they assault you, we're going to talk about subrogation here. There's going to be a soundtrack from a talk radio program that'll talk about it more. Check out my other videos, Bankster Thieves playlist, Roman Cult playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through 3, Do-It-Yourself, How Not to Volunteer for the Selective Service in the Draft, Martial Laws here, Do-It-Yourself No Income Tax, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts 1 through 13 now, I got to fix that. Canada Border Pigs playlist. Yeah, the Canada Border Pigs. I've also got one called U.S. Border Pigs. Bar Members and their Satanic Connections playlist. A penal action is an action on a penal statute. It's all about business, okay? There are no criminal acts or statutes. It's all civil. It's all about business, okay? A penal action is an action on a penal statute for action for recovery of penalty given by statute. In Texas, they have a Texas Penal Code. Well, you know, I mean, they're telling you this is all business. Where an action is founded entirely upon a statute and the only object of it is to recover a penalty or forfeiture, such action is a penal action. It's all about business. It's contracts. You have to consent. There's a contract. The words penal and penalty in their strict primary sense denote a punishment or a corporal or pecuniary imposed and enforced by state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for noncompliance with an agreement. It's a contract. The words forfeit and penalty are substantially synonymous. And even in the states where they don't call it the penal code, where maybe they call it the criminal code, like in Arizona, you read through that thing and it's got penal and penalty all over the place. So it's all about contracts. A penal action is one founded entirely on statute and brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while remedial action is one brought to obtain compensation or indemnity. A penal action is a civil suit, okay? It's a civil suit, and this guy talks about it in this soundtrack. He says, ask the judge to tell the plaintiff to certify that you have the rights of subrogation. And he calls him the plaintiff or the prosecutor, okay? He's a plaintiff. It's a civil action. Brought for recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil action on the one hand, closely related to criminal prosecution, on the other to actions for private injuries in which the party aggrieved may by statute recover punitive damages. So when you nail these whores, these clerks masquerading as judges down, they'll tell you it's quasi-criminal, okay? They don't want to tell you civil because you won't even show up. And they'll just tell you it's quasi-criminal. They're a bunch of thieves, okay? Whenever this title creates a presumption that with respect to a fact and provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. And that's the Uniform Commercial Code, Section 1-206, presumptions. And did you give up your God-given rights for some satanic privileges? Okay, you got yourself mixed up in one of these satanic contracts. That's exactly what's happened. In an action with respect to an instrument, the authenticity of an authority to make each signature on the instrument are admitted, unless specifically denied in the pleadings. And this is Uniform Commercial Code 3-308. And again, did you give up your God-given rights for some satanic privileges? What they're doing is they're forging your signature onto a contract, and then they sell it on Wall Street. This is the Uniform Commercial Code, Section 8-114, Evidentiary Rules Concerning Certificated Securities. The following rules apply in an action on a certificated security against the issuer, unless specifically denied in the pleadings. Each signature on a security certificate or a necessary endorsement is admitted. So, did you give up your God-given rights for some satanic privileges? They're selling you into slavery. There's people that have found their criminal cases found at Fidelity Investments worth millions of dollars. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those which its law and its humanity affords him. He is, for the time being, a slave of the state. It's all about slavery. If a man be found stealing any of his brethren, the children of Israel, and maketh merchandise of him or selleth him, then that thief shall die, and thou shalt put evil away from among you. These people should be put to death for doing this. And that's the first order of business is they have to get rid of their little common law problem. They don't want common law because at common law, that's exactly what would happen, okay? They got to get rid of that little common law problem. They got to get the people so asleep at the wheel that they don't have the brain cells to convene their own common law juries and their own grand juries and start putting these people to death. And that's exactly what you see out there. And the 13th Amendment, the current 13th Amendment, I'd like to qualify that, is a slavery amendment. It doesn't prohibit slavery, it makes it possible. Neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall be duly convicted, shall exist in the United States or any place subject to their jurisdiction. What a bunch of garbage, okay? That's how they authorize the slavery. They just fabricate the crimes. They create them out of nothing. They fabricate the statutes. There's no common law. Everything is by statute. They're nothing but a bunch of thieves and pirates, and it's been going on since the Civil War. And they're nothing but a bunch of thieves and pirates. They fabricate the crimes. They just make it up as they go along. Who cares? It's just a commercial transaction. Everything they do is a fraud. A U.S. citizen's a fraud. Commercial papers a fraud. All mortgages are a fraud. They get you to participate in their fraud. Then they assault you with one of their so-called contracts, their satanic contracts. Then they sell you into slavery. Everybody in prison was sold into slavery. And so what we're going to do is we're going to have a soundtrack from a talk radio program that's going to be inserted into this video, and then you can see what's going on. What this guy talks about is quite smart and presents it in what I would call a good way, and you can see what it's talking about.
Good evening, Dr. W.C.
Good evening, Fisher. How are you?
Good evening, Marty. Good evening, Eduardo. I'm a little late for the party. Hey, Fisher, if you don't mind, I remember you came in a few weeks ago talking about subrogation, and I have a court case coming up on the 17th, which I'm going to try to delay for the new year, but I wanted to try to utilize that to use it to take care of a debt that I'm falling behind on. Is this a good time, or is there another time I could talk to you about this, or can I kind of got the gist of what you were saying. It sounded like I'm acting like an insurer where...
No, here, see, okay, you're talking, okay, we did. I brought it up to Jade, if I remember correctly, for him to research. Maybe he's on the call and maybe he's actually researched it. You won't find a lot of it on the web, or a whole lot of it on the web. You have to do some really deep research, and you might have to actually avail yourself of, somebody that's in the legal field or has some experience in the legal field, like a paralegal, in most cases. But what you do when you demand of whoever's coming after you through the prosecution, whoever the prosecutor might be, You want them to certify that you have the right of subrogation. That's basically what you ask them through the judge. Will the prosecution or the plaintiff certify that I have the right of subrogation?
Okay.
That's basically all you've got to say, because it's going to stop them dead in their tracks. Because you're going in there as the surety for whatever the debt or obligation might be, as the court sees it, or as the plaintiff sees it, because they usually see it the same way. But what you're doing is you're taking your place, you're replacing yourself or moving yourself through the certification of your right to subrogation to alter your stance. You quit being the surety or the trustee to be responsible for the charges, and you actually become the plaintiff, and you own the court case, and you own the bonds that the plaintiff or the prosecution had to put up to insure the case to the court.
So does that mean that by being in that position and being the person in charge of the bonds, can I offset that debt?
Oh, sure.
At the same time?
Yeah, because, see, once you, and they cannot refuse the right to be subrogated. They cannot refuse it. Even the Supreme Court has said so. There are various cases on this. But once you ask the court for a certification of your right to subrogation, they're either going to say yes, or they're going to say no, or they're going to be very silent, or you're going to hear a lot of hems and haws because they don't know what to say, but he can't refuse it. So even if you don't get an answer, you just basically make an offer to offset whatever the obligation is right then and there. But you wait for their answer to see what they're going to say. Tell them you'd like it in writing, a certification of your right to subrogation.
And if they decline looking at me like this person
they can't decline. If they decline, then the judge has to step in, because he knows that if he allows them to decline, then he's probably going to be looking at an appeal where he's reversed.
Can the judge lose his bond too at the same time for now?
Oh, yes. Yeah, he can actually lose his job.
Okay, so the first, I understand about getting a paralegal. I know of one, but what are the odds of a paralegal or even an attorney wanting to, or even to know enough about subrogation to know that?
They know about it. They know about it, but it's so little used. It's not necessarily a secret, but it's not something they want out in the public venue, because everybody would start using it, like even in a traffic case or a parking ticket. See, and then they own the case, and if everything works the way it's supposed to, what is supposed to happen is the prosecution or the plaintiff, and it's usually the same party, through the prosecutor anyway. Right. He has to give you the court file, and he has to give you the court bonds that he's put up to ensure that somebody pays the damages on the case. See, a lot of people don't understand this. When a prosecutor brings a case into court, he has to put up a bond. Okay, we always talk about cases being bonded, and the bonds are sold. People like Walmart buy them, blah blah blah. Mm-hmm. But there are several bonds. There's a performance bond. There are several bonds, about 3 or 4 of them, depending on what the case is. But he has to turn the bonds over to you. You can take the bonds down to the court clerk downstairs, and they'll actually write you out a check for the value of the bonds if everything works perfectly, if that's what you want. And that actual money is coming from my actual TDDA account, is it not? We're not talking about that, but yeah, that's where it comes from, yeah. See, the reason an attorney or a lawyer has to put up a bond, and it's guaranteed by his bar card. Have you ever heard that every attorney that goes into court has to take his checkbook with him? I heard that terminology a long time ago, but it just kind of went in one ear out the other. Yeah, well, see, if he loses the case, he has to write out a check to the court because he's guaranteed he will find a victim to pay for the charges to cover the bonds.
Now that I never knew about. Never heard of.
So if he loses, he has to write out a check.
But that's where he's protected with the bond, where he's bonded, correct?
Yeah, because the court uses those bonds to finance itself.
Okay,
that is absolutely amazing. Excuse me, Art.
Sure.
Because now that just gave me the reason why they use public defenders, because they know that they are working for the court to make sure that the defendants lose so that the attorney can hang on to his money.
Well, it's not just that, WC. Before the court can go into your TDA and extract money from it, they have to have 3 signatures. You want to guess what those 3 signatures are?
The judge, the public defender, and the attorney.
That's right.
Wow, that is absolutely corrupt.
No, they don't. No, because if you have allowed yourself to be subjected to being a ward of the court or incompetent by accepting the public defender or hiring your own attorney, they don't require anything from you. It takes 3 members of the court to sign to make sure that your TDA money is released into the court.
Wow.
But what happens if I represent myself, Fisher? Then you're looking at 2 signatures.
Well, see, why do you think they want you to have a public defender or an attorney?
Right. But in my situation, to be realistic,
I wouldn't. No, I wouldn't accept it. You can hire an attorney if you want, but don't let him talk for you. Have him there as a consultant only.
Yeah, I see. Well, to tell you the truth, I can't afford an attorney at this moment, in this moment right now. But so I'm going to be representing myself, and like I said, I'm going to try to delay it for the new year. But so I have a little more time to
when
check more. When are you supposed
to go to court?
The 17th. I'm in Ohio now. I'm back to work as a contractor in Ohio, but it's in Ohio. It's in Florida, and it's on arrearages, child support arrearages, which I was fine. So,
well, okay. See, now this brings up another thing. I wouldn't argue this, but just so everybody understands, you understand. No, were you married?
Yes, I was.
Okay. Now, you went down and got a marriage license, right?
Yes, I did.
Okay. That made the state a third party in your marriage.
Mm-hmm.
Okay. So if they're a third party in your marriage and they can come in at some point in time because of something they hear or some allegation or some rumor, right, like support enforcement or Child Protection Services comes in and says, we hear you've been, doing this, that, or the other thing, and we're going to take the kid out of the home. Okay. As a third party as to the marriage, they have the right to do that. Mm-hmm. But at the same time, if they're a third party and they have that right to do that, why don't they ever pay their fair share of the child support?
Good idea. Good question.
Well, I was checking on YouTube a little bit, Fisher, and I don't know how true this is, but some guys were coming up with the statement stating that, let's say, my child support's $700 realistic. That's what it was at one time, $700 a month. And I never got that adjusted. But anyways, the state actually gets that money from the feds to whatever that amounts to, but yet they also want me to pay child support on top of it. And basically from what the guys were saying online or on YouTube was that whatever is collected that the state collects, the feds pay that amount. And
well, they didn't explain it fully. They did not explain it fully. What happens normally in a child support situation like that, especially where somebody's in arrears, is the welfare agency, whatever you want to call it, steps in, and they're the ones that actually get the money, and they give the mother or the child whatever they want to. But they do get matching funds from the feds in the event the mother is on welfare or the child is.
Oh, really? Okay.
Yeah.
Oh, I see. All right. I thought they were getting the state was getting it anyways from the feds.
No, if the mother goes on any type of federal assistance, and that includes food stamps, or the child does, there are matching funds provided by the federal government. But when you pay your child support, unless it's been stipulated by the court that awarded the divorce decree and made the decree that you pay the child support, the only way it can go directly to the mother in any case is if the judge specifically ordered that in writing, which they very seldom do anymore. They just say, you have to pay child support, and here's where you send it. But it usually goes to whoever runs the welfare organization or agency in the state.
Well, here's the thing, Fisher. It started in Arizona where I got divorced, okay, and
they just transfer around wherever they have to.
Right. So my residence is Florida. So Florida stepped in saying you got to come to court because you haven't paid in a few.
Yeah, because they'll want to take your driver's license and your birthday and all that stuff. Yeah.
Yeah. So I don't know what they're gonna do because I'm back to work and I'm working, but I had to take some time off of hardship for my folks. And then when the hurricane came, I was going to start in September, but the hurricane came, so I stopped. So I guess that extra month did it, where you got to go to court, you're not paying, and we don't want to know why, and bring your checks, and what you made, and so on. So I mean, it's already coming out of my paycheck, but this all happened before I started working again. And anyhow, all right. I got the gist before, and now I understand a little bit more. I do have a friend that is a paralegal. I'm going to talk to her about it, and basically, if I represent, I am going to represent myself, and I will ask the courts on the prosecutor to state that.
You want them to certify that you have the right of subrogation. That's all you've got to say.
Okay.
Will the prosecutor certify my right to subrogation?
Gotcha.
And you ask that to the judge, and you're probably going to see him smile because it's gonna surprise him that you know about it. It's going to shock the prosecutor, and the judge is going to slam the prosecutor if he doesn't do the right thing.
So it's almost like just by that statement alone, it's a win-win situation for me.
Yeah, you can't lose because they cannot refuse your right to subrogation. Because you have to remember, again, look at your court papers. Who is it that got ordered to pay child support? Is it all uppercase name or is it your name?
Yeah, it's in my fiction name, exactly.
Yeah, okay. See, now you see, you're the surety for the debt. Because you're the government-issued entity known as the uppercase name can't pay the bill. So who are they going to come to? You see how stupid this is? I mean, you're the biological father, right?
Right.
Can an uppercase name be a biological anything? But this is how dumb this court system has become. Because, see, even if you paid the child arrearages and you had an attorney, defending you or trying to defend you, as you think he might be trying to do. But what is an attorney's job? Is to take your stuff and to give it to the queen.
Yeah.
Okay, so you're never going to win if you hire an attorney because you automatically become incompetent and a ward of the state, which means the judge doesn't have to hear a damn thing you say because you're incompetent.
All right. Well, that was a lot simpler than I thought, Fisher, and I really appreciate you giving me that feedback again, and I understand a lot more. And the terminology.
It's a very interesting subject, and it's there's not a lot out there on it, and there are very few people that even talk about it or know about it.
Subrogation. One who is not a party to a given transaction, especially someone other than a party or the party's employee, agent. Oh, this is talking about a stranger, okay? One who's not a party to a given transaction, someone other than a party's employee, agent, tenant, or immediate family member. Now, this actually, the very end is the one, this definition number 3, a person who voluntarily pays another person's debt, even though the payer cannot be held liable for the debt, and the payer's property is not affected by the creditor's rights. Subrogation does not apply to a stranger if the debtor did not agree to or assign subrogation rights. Okay, so again, as when you subrogate, when you pay the other debt, they subrogated their right to you, and so now you have the right to subrogate to reassign that debt. Okay, and what these pigs are doing is they're stealing it and going and taking it themselves. Okay, so when you bring up the issue of subrogation, you're just blowing that bubble big time, okay? Because you have the right to subrogation. If you don't use it, then they'll do it, and that's what they do. Okay. Subrogation is an equitable assignment. The right comes into existence when the surety becomes obligated, and this is important as affecting priorities. But such right of subrogation does not become the cause of action until the debt is fully paid. Subrogation entitles the surety to use any remedy against the principal which the creditor could have used, and in general to enjoy the benefit of any advantage which the creditor had, such as a mortgage lien, power to confess judgment, to follow trust funds, to proceed against the third person who has promised either the principal or the creditor to pay the debt. And that's, again, taken from Black's Law Dictionary, 8th edition. And so, again, this all comes down to subrogation, and this is like really, really powerful. This really puts them in a bad situation. Legal subrogation, a subrogation that arises by operation of law or by implication and equity to prevent fraud or injustice. Legal subrogation arises when the paying party has a liability, claim, or fiduciary relationship with the debtor. Okay, remember we talked about that Braswell case where if you're an officer of the corporation, okay, the same thing. The paying party has a liability claim or a fiduciary relationship with the debtor. Okay, they're basically assaulting you with that. The party has to fulfill a legal duty or because of public policy, or the paying party is a secondary debtor, or the paying party is a surety. The party pays to protect its own rights or property. And so, again, that's legal subrogation. That's exactly what's going on here. One of those for sure, maybe more than one. And so, again, this is all about subrogation. When you tell them you want them to certify that you have the right to subrogation, that kills them. Okay, they'll make it go away. That kills them. And when you bring that up, you bring that on the Court of Appeal. They're nothing but a bunch of thieves and pirates. It exposes them for what they are exactly. Anyways, that's it. That's about subrogation. I hope you like it, and definitely use it against these thieves and pirates. Have a great day.